Hello, everyone. This is Undiga, the Niger fertility lawyer. Today, I'd like to say a few things about legal representation for the surrogate and the importance of getting her own lawyer. It's important to point out that a surrogacy agreement, an agreement where a woman agrees to get pregnant through assisted means and carry a pregnancy on behalf of someone else is considered to be one of the most intrusive contracts that a woman in particular, is capable of entering into. A lot of people consider that there is no price that you can put on that kind of service, and some people frankly believe that surrogacy arrangements and surrogacy contracts are not only illegal but highly unethical. And so, because of the intrusive nature of a surrogacy contract, just imagine somebody decides to use her body to perform a contract that would take her 9 months to fulfill. And when at the end of the day, she will produce a baby who she would not be even very often be allowed to see and will not have the opportunity of nurturing. Because of the sensitivities around surrogacy contracts, a lot of countries integrate requirements for informed consent for the surrogate in order to allow such an agreement to go through, in order to accord that contract legal recognition and allow the contract to be enforceable. Now, the importance of informed consent in law is that informed consent gives the surrogate the opportunity to be fully informed of all the risks and the benefits of the surrogacy contract, and to give her permission and to give her consent to the contract in full knowledge of all this information, both good and bad. In many countries, if there is no evidence of the fact that the surrogate gave informed consent to the contract, the surrogacy contract to be considered void and unenforceable. And in order to avoid that end result, such countries will impose a requirement that the surrogate, before the surrogate can sign the surrogacy agreement, that she must give informed consent, and that informed consent must involve the participation of her own independent lawyer. In many cases, it's convenient to get a lawyer, usually the lawyer of either the hospital or the intending parents, to draft a surrogacy agreement, and that lawyer would advise everybody, and everybody huddles around the table and they sign. But when it comes to the surrogate, because the surrogate is always considered a vulnerable party with unequal bargaining power in relation to the intending parents, it's considered that she needs her own lawyer who will be able to give her independent and unbiased advice about whether or not to go ahead with the contract as has been drafted by the legal representatives of the intending parents. And so it's a safeguard, if you like, is considered an internationally acceptable safeguard to check a surrogacy agreement to see whether or not the surrogate got legal advice and whether or not she had received advice from that legal advisor before she signed the contract. So in that situation, independent legal advice in some countries is actually a requirement for the enforceability of the contract, to the extent that if an intending parent leaves their own home country and goes somewhere else for a surrogacy agreement, if there's no evidence that the surrogate had independent legal advice, that the validity of that contract will be called into question. Because in such countries, it will be considered that the surrogate was poorly informed and was not in a position to put her signature on the contract, and that because she was poorly informed, that she probably would have rejected the contract because she didn't like some terms of it, or because the contract was considered exploitative. So the failure to get independent legal advice for the surrogate would be taken as being indicative of a desire or an intent to exploit the surrogate. And so the presence of another lawyer who was independent of the intending parents and who was not the same lawyer who drafted the contract will be seen as evidence of the intending parents' intent to make sure that the surrogate entered into the agreement freely. So, in a surrogacy agreement, evidence of the fact that the intending parents made arrangements for the surrogate to have an independent legal advisor who advised her as to the terms and implications of the contract prior to her signing will be seen as evidence of good faith on behalf of the intending parents and evidence of the fact that they had no intention to exploit, that the surrogacy agreement was fair, the surrogacy agreement was not exploitative or coercive or otherwise tainted by any other defects. Because it's very likely, the idea is that it's very likely that if the surrogate was advised by an independent legal advisor, that independent legal advisor would have told her about any terms and conditions of the contracts that were unfavorable to her or which were not in her interest, and probably help her argue to have such terms and conditions amended. And so it's very important in international surrogacy in particular that the intending parents make arrangements for the surrogate to have independent legal advice, and that independent evidence of that independent legal advice is provided in the documentation, so that when they begin to implement the exit strategy to remove the child from Nigeria, there'll be evidence of the fact that the surrogacy agreement was above board, as evidenced by the fact that the surrogate signed the agreement only after she received independent legal advice. I hope you took value from this video. Take care out there.